So the first hard question, again, we're skipping past can you cross-examine someone you know to be telling the truth, because I think the answer is self-evident, is you have a perjurious defendant. And the rule that bears on this is Model Rule 3.3. A lawyer shall not knowingly offer evidence that the lawyer knows to be false. And that knows is significant. And Rule 3.3 has a special carve-out for the testimony of a defendant in a criminal matter. This is all part of the same rule. Subsection 3, a lawyer may refuse to offer evidence other than the testimony of a defendant in a criminal matter, so a specific carve-out that the lawyer reasonably believes is false. And so there's a lot about, in the case law, there's a lot about what do you know, what do you have to know in order for this rule to be applicable. Have you ever been confronted with either a witness or a defendant?
I've been certainly confronted with a witness that I knew was going to lie. And again, this was when I was a prosecutor and did not put that witness on. And then it comes down to what's your obligation, right? How far do you need to go to determine whether or not what they're going to posture to a jury or to the court is true, right? And so you certainly need to do your due diligence, but sometimes you're in a meeting with someone and you can just tell that they're lying to you, right? And so what do you do to corroborate that? Because at the end of the day, prosecutor, defense lawyer, all you have is your reputation. All you have are your ethics, right? And so certainly you need to be a zealous advocate for your client, but at the end of the day, you can't do that if you don't have your license. And so I really feel like if you feel as a lawyer that, this individual is going to be perjuring themselves and you're going to be the one doing the direct examination of that testimony, I wouldn't put them on.
And so when you were confronted with that witness as a prosecutor who you felt was going to perjure himself or herself, were you close to trial? Was this someone that you were planning as calling as a trial witness?
Close to trial, right? It's always right at the end of the day when you're preparing and you have your, the statement, a prior statement by the witness, and you've prepared and you're doing your trial prep, and then all of a sudden the story changes, and certainly in the heat of the moment when someone's interviewed, they're more likely to be truthful, than maybe a year and a half later when they've really thought about it. And we're going to get to witness tampering later, perhaps, someone spoke to that individual, and maybe there's a reason why the testimony has shifted or changed. And certainly then as, defense lawyer, you have different considerations as a prosecutor. If you put that person on, then you have the obligation, obviously, to give inconsistent statements to opposing counsel. And so you have to consider whether or not this is a witness you really need for your case.